Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to be looking at some cases from New York that involve serious injuries, specifically a back surgery, usually to the neck or the lower back, and it's known as a fusion surgery. Each case is going to be unique, and I picked out a few cases that I thought were interesting. So the first case is actually a laborer who was injured after a staircase collapsed. And this happened in Kings County, which is Brooklyn, New York. And the lawsuit was filed in 2017, and the trial happened in 2022. So it took about 5 years to get to trial. On December 14th, 2016, the plaintiff, who was 55, he was a laborer. He was working at a construction site in Brooklyn. And as part of his job, he used a temporary staircase that was leaning against the balcony. And as he attempted to walk down the staircase, it collapsed underneath him. And he fell 10 feet to the ground. And there were injuries to his neck and back, and it actually rendered him a quadriplegic. So he sued the property, which is the owner, an LLC, and he alleged that they violated the labor law, which says that they have to provide proper protection for workers. And the landlord filed a third-party claim against the construction company that was this injured person's employer. So they filed a third-party lawsuit against the employer and also the project's contractor. So that's basically what the case was about. Now let me see if they have more information. They filed a motion for summary judgment, and so I believe that the motion was granted, and then they filed an appeal. So it was up on appeal at the time of the trial. There was issues as to liability. I think they had to try some of the liability. And then the injury, like we talked about, was very serious. It was there was a teardrop fracture of the C3 vertebrae. And so that led to a type of quadriplegia. There were a lot of really serious injuries. So the experts that the plaintiff had was a life care planner for the future economic loss and future medical expenses, all the economic losses. There was a neurosurgeon. There was a construction, or rather a PE, an engineer for construction safety. There was a doctor in physiatry. There was an economist. There was a physical medicine doctor. There was a doctor for psychology and counseling. And there was also a urologist. So all of those experts. And at the end of the day, the jury rendered a verdict for $46.25 million. And with the addition of $1.7 million in stipulated economic damages, it actually turned out to be $47.9 million. So a really, really pretty high verdict. It was $15 million for past pain and suffering, $11 million for future medical expenses for a period of 21.5 years, $20 million in future pain and suffering over the same 21.5 years, $250,000 for future lost earnings over 6 years, and so the total was $46,250,000. And it was a 13-week trial. The jury deliberated for only 4 hours, which is pretty quick after 13 weeks. And they voted 6-0, so all the jurors agreed. So that was the first case. Now the next case, this is also an interesting case. What happened here was also in Brooklyn. And this one happened in November of 2023, so fairly recently. And it was a 30-year-old man. And what happened was on April 21st, 2016, so it happened in 2016 and the trial wasn't until 2023. So you have about 7 years. A construction worker in his 30s was doing demolition work at a school in Brooklyn, and he was using a handheld grinding tool with a wood saw blade. While he was cutting the flooring with the tool, the blade kicked back and it cut his right leg. And so he sued the property owner, which was a realty company. And what happened was there were a few lawsuits. They were consolidated. And he claimed that on the date of the incident, his boss had given him the grinding tool, which was allegedly missing a safety guard. And the plaintiff's attorney was arguing that the guard would have prevented the injuries. And so it was also a labor law case, but it wasn't a gravity-related case, but rather it was a 241-6 case, which has to rely on a violation of an industrial code. And here they allege that the violation was for Industrial Code 23-1.2C1, which states every portable, power-driven, hand-operated saw shall be equipped with a fixed guard above the base plate, which will completely protect the operator from contact with the saw blade when the saw is operating. So if you have a violation of that and the jury believes the violation, then that could be sufficient for the 241-6 claim. And so he claimed another violation about safety devices and safeguards. And so the defense claimed that the changed the blade on the saw and was therefore liable for the accident. They're basically saying that the plaintiff changed the blade and he was liable. And so the injury was that he was taken to the hospital. He had a severe right thigh laceration. Also claimed herniations from C3 to 4, C5 to 6, C6 to 7, and L5S1. And he ended up having spinal surgeries, 3 spinal surgeries, an L5S1 microdiscectomy, a C5-C6 anterior cervical decompression and fusion with bone graft, and an anterior and posterior L5S1 fusion. So 3 different surgeries. So the jury determined that they had violated the industrial codes, and they further determined that these violations constituted a failure to use reasonable care and that the failure was a substantial factor in causing the accident. So they concluded that the plaintiff was negligent, but determined that his negligence was not a substantial factor in causing the accident. It was only the defendant's negligence that caused the accident. And so at the end of the damages trial, the jury concluded that defendant's negligence was a substantial factor in causing the plaintiff's injuries, and the total award was $19,774,000. So a pretty large award. It broke down like this: $300,000 for past lost earnings, $5 million for past pain and suffering, $204,000 for future pain and suffering, for future pain management visits for 32.7 years, $314,000 for neuromodulation hardware maintenance for 32.7 years, $108,000 for future orthopedic and/or neurology visits for 32.7 years, $1,096,000 for future interventional treatment for 32.7 years, $860,000 for future physical therapy, also for 32.7 years, $988,000 for future pharmacological management, all the pharmacies, all the prescriptions, that was almost $1 million for 32.7 years, and $10 million for future pain and suffering, and $900,000 for future lost earnings for 17 years. So the total was $19,774,000. And I know the judge that was involved had actually tried cases before this judge. The trial length was 23 days. The trial deliberations were 2 days. The jury vote was 5-1 on plaintiff's negligence and whether his negligence was a substantial factor in causing the accident, and 6-0 on all the other questions. It says the offer before trial was only $500,000. So I guess it was a pretty good result considering the offer. And let me go over the experts real quick. So the plaintiff had a spinal surgeon. He had an economist, a pain management doctor, a radiologist, and another spinal surgery doctor. I guess different doctors did, because he had 3 spinal surgeries, different doctors did different surgeries. The next case is a little bit different. This was in the Court of Claims in Albany, and this was also a fracture of the neck at C3, and the plaintiff was a male, 44 years old. What happened here was on March 17th of 2013, the claimant, who was 44 years old and an investment banker, was skiing at Whiteface, which is in Lake Placid, a ski resort. The resort's attractions included a stunt ramp that allowed skiers performance of acrobatic jumps. And so a 50-foot by 50-foot airbag was situated alongside the ramp as a cushioned landing area. So the plaintiff performed a backflip off of the ramp. He landed headfirst on the airbag and suffered a paralyzing injury of his neck. So he sued the resort's owner, the state of New York, and the resort's operator, the New York State Olympic Regional Development Authority. Because they had the Olympics there many years ago, so I guess the Olympic Authority is the developer, right? Or the operator rather. And then the state of New York is the owner. So you have to go through the Court of Claims, which is a special court. And the lawsuit alleged that the defendants negligently created a dangerous condition that caused this injury. The airbag comprised two inflatable chambers, an upper chamber and a lower chamber. The inflation process required use of two manufacturer-provided blowers, each of which inflated a different chamber. And the plaintiff's lawyer argued that the lower chamber had not been inflated and that the upper chamber had not been fully inflated. He claimed that the airbag was therefore too soft and allowed the plaintiff's head to strike the ground beneath the airbag. And the airbag's principal operator had been trained by the device manufacturer, but claimed that he did not understand that the airbag's chambers had to be separately inflated. He claimed that he typically utilized only the blower for the upper chamber, erroneously believing he was inflating both chambers. So on the date of the plaintiff's accident, the airbag was inflated by a coworker who had been trained improperly by the airbag's principal operator. And so the defense argued that the plaintiff's headfirst fall could have had a paralyzing effect if the airbag had been fully inflated. So basically, even if we had this inflated, proper inflation, it still could have paralyzed him because he hit head first. That's dangerous. And it's kind of like a risk of the activity. The defense claimed that plaintiff had previously undergone fusion of his spine and was therefore unusually susceptible to this injury. And the defense also attempted to invoke the doctrine of assumption of the risk based on the plaintiff having signed a waiver that disclosed the possibility and thereby having assumed the risk of injury. So you sign a waiver, they tell you this could include serious injury, paralysis, death. However, the plaintiff's lawyer argued that plaintiff assumed the risks relating to the use of a properly inflated airbag, not those related to an insufficiently inflated airbag. So yeah, it's a risk of the activity, but it's not a risk that you won't have the safety measures that you should have. What happened was the injury, like we talked about briefly, was a C3 and C4 fracture. He was airlifted to a hospital, underwent fusion, C3 and C4. He was actually comatose for several days, and he had 107 days of rehabilitation. He suffered quadriplegia. He had respiratory functions impaired and required constant monitoring and required assistance on all his activities, could not resume work. His wife had to provide constant care, support, and companionship. They had to relocate from New York to Los Angeles for access to advanced treatment for this condition, and the couple's home had to be modified to accommodate these disabilities. And he sought recovery of past and future medical expenses, damages for past and future loss of earnings, and damages for past and future pain and suffering. And his wife sought recovery for loss of consortium. So during the month right before the trial was scheduled, the parties negotiated a settlement, and the state agreed to pay $15 million. So also a pretty high settlement. I mean, these are terrible injuries, quadriplegia, but a pretty high settlement. The next case is a case in Queens, and this is a case that happened in April of 2015. That's when the case happened. And the incident happened earlier. It happened in 2009. So you can see some of these cases take quite a while. This was close to 7 years, from 2009 to 2016. So the plaintiff was a 43-year-old security guard, and he was driving on 188th Street near Hillside Avenue in Queens. And while he was proceeding through the intersection, he stopped in traffic, and the traffic control officer directed him to a bus stop that was located immediately beyond the intersection. When the plaintiff reached the bus stop, his van collided with or was struck by a bus whose driver was attempting to stop at the bus stop. And he argued that he sustained injuries to his back and neck. So he sued the bus's driver, the bus's operator, which is the New York City Transit Authority, and he basically argued that the bus driver was negligent in operating his vehicle, and he further argued that the New York City Transit Authority was vicariously liable for the bus driver's actions. He claimed the collision occurred while his van was stopped. He claimed that the bus driver approached from the left and initiated a side sweep collision. And the traffic control officer did not appear at the trial. During the deposition, he claimed that he did not recall the circumstances that led to the incident. The bus driver claimed both vehicles were moving when the collision occurred. He argued that the plaintiff was really mad because it was being ticketed by the traffic control officer, so he deliberately initiated a collision. The plaintiff's attorney challenged that bus driver's credibility and noted that during the deposition, the bus driver claimed that his bus was stopped when the collision occurred. So now he's changing his testimony. So that's not so good for the bus driver. The injuries were a herniated disc at C5, C6, and pre-existing herniations at L4 and L5 that were aggravated. There were 17 weeks of physical therapy. There was ongoing pain. In 2010, he had surgery that included a discectomy, which involved excision of the anterior portion of the C5, C6 disc, fusion of the corresponding levels of the spine, and implantation of a plate and 4 screws. And he underwent another surgery in 2012, which included a laminotomy, excision of portions of his T9 and T10 vertebrae, implantation of a device that provides pain-relieving stimulation, so a spine stimulator. And the procedure was followed by an additional course of physical therapy. And so the plaintiff claimed that during his treatment, he was unable to independently perform many of his everyday activities, such as bathing and dressing himself. He further claimed that his back and neck remained painful and that his pain worsens during bad weather, and that his pain interrupts his sleep. His pain hinders his performance of physical activities, such as negotiating stairs, operating motor vehicles, and that his pain prevents his resumption of work. And he claimed that painkillers provide some relief, but that they cause drowsiness and lethargy. And so as he sought recovery of his medical expenses, and as well as pain and suffering, and defense counsel argued that the accident involved a relatively mild collision that caused merely minor vehicular damage. He argued that a collision could not have caused the injuries that the plaintiff claimed to have sustained, and also argued that plaintiff's surgeries were unnecessary procedures taken for secondary benefits. So basically he's doing these surgeries to make money, and typical defense. So the defense counsel retained an expert neurologist and an expert orthopedic, but neither testified during the trial, and the judge during the trial ruled that the jury could draw an adverse inference from the doctor's absence. I'm not sure why they would retain the doctors and not call them. Maybe the doctors were not available, or they sometimes doctors move out of state or retire or whatever reason, but so that could be an adverse inference. You could infer that the fact that, hey, where are these missing doctors, you could infer maybe that the testimony wouldn't be so good. So that was helpful to the plaintiff. The jury found that the defendants were liable for the accident, and it determined that the plaintiff's damages totaled $12,535,000. So pretty significant amount also. And it broke down like this: past medical costs were $150,000, future medical costs $250,000, past lost earnings were at $92,000, rather lost earning capability, and future lost earning capability was $301,000. Past pain and suffering was $3 million, and future pain and suffering was $7 million. The trial took 9 days. The jury deliberated for 4 hours, and the vote was 6-0. So pretty good result as well. $12.5 million, a pretty good, really good result for a 43-year-old, especially if the crash between his car and the bus was minor property damage. That's one of the arguments that they make, and it looks like the only expert called was the orthopedic surgeon who performed the surgery. That's the final case. That's the final case in this particular research that I did. I just kind of pulled up a bunch of cases in New York that had this back surgery, and I went through some of the cases, and I was trying to, find something that's a little bit different, a little bit interesting. Like the skiing case is a little bit of a different type of case. This was a car crash. One was I think just the $46 million one I kind of included because it was, I think, the highest one. And if you go to the actual results, there were a lot of cases. There were 878 cases. So that's a lot. You can't really talk about that many cases. The average, the median, is like 1.5 million. Or actually, that's the median. The average is 2.3 million. The lowest is 44,000, and the highest, according to the value range anyway, is 19 million. But the actual highest, if you sort by amount, is this 46 million one that we covered. Okay, I hope this was helpful. Let us know what questions you have, what videos you want to see. We are here for you. Our goal is helping serious injury victims and families. Please like and subscribe to our channel, and we will see you very soon. Okay, everyone. Bye-bye.